Welcome back to a new post today. Let's once again begin the weekly polity and economy for this week for the upcoming mains examination of 2025. So this is a complete one-year weekly session where we have on Sundays or Saturdays where we cover the weekly current affairs with regard to polity and governance and also the economic aspects, and fortnightly we cover the international issues. So let's see what are the important politics and governance issues with regard to the UPSC Civil Services Mains Examination. The very first thing is about West Bengal passing a resolution saying that they stand for United West Bengal. Now this news came up because of Jharkhand MP who belongs to the BJP, Nishikant Dubey, who demanded for the formation of a new union territory by bifurcating certain districts of Bihar, Jharkhand and West Bengal. And on the other hand, the Union Minister and State President Sukanta Majumdar has proposed the North Bengal to be a part of the Northeastern Council. So the Bengal Assembly therefore passed a resolution in a voice vote even last year against the attempts to divide the state. The basis for the arguments put forward for the formation of union territory is to tackle the increased undocumented immigrants from Bangladesh. And Dubey, while speaking in the Lok Sabha in the recent budget session, said that the union territory to be carved out of Malda and Murshidabad districts of West Bengal, the Araria, Kishanganj and Katihar districts of Bihar, and the Santal Paraganas region of Jharkhand. The MP from Jharkhand Goda constituency claimed that the tribal population in the Santal Paraganas region was declining due to influx of undocumented immigrants from Bangladesh. And Dubey sought to justify his demand for carving out a union territory by claiming that Jharkhand High Court allegedly said that the Muslim population was on a rise in the state and hence the centre should intervene. The BJP legislators therefore called for implementation of the National Register of Citizens in the region, and the National Register of Citizens is proposed exercise to identify the undocumented immigrants. And therefore the West Bengal government passed a resolution against the division of West Bengal, saying that development is their motto. Let me tell you that the power rests in the parliament with regard to formation of states, union territories, redrawing of the boundaries, even change in the name, etc. Therefore the Federation of India is described as an indestructible union with destructible states that can be done only by the parliament and even sometimes against the wishes of the states. For example, recently the latest union territory to be formed in 2019 was Jammu and Kashmir and Ladakh. So bifurcating Jammu and Kashmir in 2019, we celebrated 5 years of this today, just day before, and this was the last change that the government of India made. So this is about how you describe the Federation of India. Changes with regard to the states, the boundaries, the name of the states can be done under Part 1, that is Article 2, 3 and 4 of the Indian Constitution. And so the demand for new union territory is based on the arguments given by the BJP MPs. Now at a very right time when we are celebrating 5 years of formation of the Jammu and Kashmir Union Territory, now a human rights body has called for immediate announcement of elections in Jammu and Kashmir to get it back to a statehood with a representative body. So the Forum for Human Rights in Jammu and Kashmir, led by a group of concerned persons, which may be called as pressure groups, has called for the immediate announcement of dates of Legislative Assembly elections in J&K before the Supreme Court's deadline of September 30th, arguing that the security would not be security should not be a consideration given that elections have been held in far worse situations even before this. So the forum was formed in August 5th, 2019. When the special status of Jammu and Kashmir was revoked under Article 370 and 35A of the Constitution and divided Jammu and Kashmir into the union territories of J&K and Ladakh. Now it is chaired by the former Union Home Ministry J.K. Pillai and Radha Kumar, the former member of the group of interlocutors for J&K, the chair of the forum. So this is a very timely report, I would say, by the forum, which brought out the highlights of the impact, especially on human rights, since the scrapping of the special status of Jammu and Kashmir. So let me just highlight some of them. It says that it demanded for restoration of statehood because it is the elected representative which will understand the needs of the people better. Insecurity persists. It says that targeted attacks on the Pandit and the migrant workers, both from Hindu and Muslim, continue. It also gives data with regard to this. It also speaks about growing militancy in Jammu. The village defense guard guards have been targeted, it says, and also this included increase in the number of casualties with regard to the police and the CRPF. It also says about the spread of militancy in the region. It noted after decades of peace and bordering of Poonch and Rajouri districts in Jammu and Kashmir, now this has re-emerged as a locus of militancy and cross-border infiltration from Pakistan. So the forest belts connecting these districts have been routes of infiltration. The other point it highlighted is continuous civil rights abuses with regard to gross violation of freedom of expression, movement, especially with rights to the media, safe working environment, arrests of the students, the journalists, the lawyers, and even businessmen under the draconian Unlawful Activities Prevention Act and the Public Safety Act continue despite judicial attempts to limit their application. Citing news reports, the forum said that over 2,700 people were booked under the Unlawful Activities Prevention Act, the Public Safety Act in 2002, and in December 2023, 1,100 of them as underground workers or facilitators of armed insurgents. It also speaks about custodial deaths and torture, let me tell you. So it speaks about crimes against scheduled castes and scheduled tribes that have increased from 0.20% in 2020-21 to 1.20% in 2023, and also crimes against the scheduled tribes have gone from 0 to 0.10%. Crimes against women and children have been documented by the report of the forum. It says it has increased to 3,116 in 2022 from 3,000 and yes, it has increased. And it also speaks that it has hurt the scrapping of the special status has hurt the economy of Jammu and Kashmir, saying that the state's net domestic product, which grew at an average of 13.28%, now became very, very less to 8.73% because of separation of Ladakh as well. And also speaks about the increase in lockdowns, protests, COVID-19 impact, stole pelting impact, the removal of the special status impact on the economy. It also speaks about unemployment and rise in drug abuse in the state. So it speaks unemployment is higher than the national average. It speaks of import on duty cuts on the local industry. It says that the import duties that have been cut on the walnuts from China, Turkey, US, apples from Washington, the saffron from Iran have hurt the local producers with regard to dry fruits, that walnuts, apples and saffron in Kashmir as well. And land acquisition now continues to be implemented high-handedly. This is what it says. It also says that the Human Development Index shows many deficits with regard to Jammu and Kashmir, and on many of the indices, data has been hidden by the center. It also speaks about suicide and depression being high among the youth between the age of 15 to 35 because of the situation in the newly formed Union Territory. So these are some of the highlights. The next most important issue is about the LG, now which has been a bone of contention between the center and the elected government in Delhi. So recently Supreme Court says that the LG has the powers to appoint the aldermen to the Delhi Municipal Corporation without the aid and advice of the Council of Ministers and the Chief Minister in Delhi, and this it says after 15 months. However, previously in one of its judgment it says that the LG has to act on the aid and advice of the Chief Minister and the Council of Ministers, but this time the Supreme Court has changed the position, saying that the LG has the power to appoint the aldermen who has special knowledge and experience of municipal administration to the Delhi Municipal Corporation without the aid and advice, and this has been mentioned in the Delhi Municipal Corporation Act of 1993, which was previously 1957, but it was amended in 1993, giving special powers to the Lieutenant Governor. So the case was reserved for judgment by D.Y. Chandrachud, Narasimha and Pardiwala, and they ordered the judgment. The bench held that the LG special powers drawn from the Section 3 of the Delhi Municipal Corporation Act, and once again giving more powers to the Lieutenant Governor. And recently, and this has been taken as a hit to the elected government of the Aam Aadmi Party in Delhi, therefore even stifling the voting, the verdict of the people by giving more powers to the to the Lieutenant Governor. Last year in May 2017, the Supreme Court had held that giving the LG the power to nominate the aldermen to the municipal corporation would mean that it would destabilize an elected body. The top court said that the LG, with the power to nominate the aldermen will effectively mean that he can destabilize a democratically elected MCD, because these aldermen get an appointment to the standing committee and have voting power. Now let me tell you, MCD has 250 elected and 10 nominated members. All the 10 nominated members can be nominated by the LG without the aid and advice of the Chief Minister. And Assam is coming up with the new domicile policy. Now there are certain states with regard to special provisions in the constitution under Article 371 where domicile policy can be adopted, and Article 16 also says that the Parliament can bring about a law specifying the domicile for any individual with regard to appointment to any post in the government services. This is said in the Article 16. Assam Chief Minister announced a new domicile policy where only those born and domiciled in the state will qualify for government jobs, addressing the demographic concern. Additionally, the law with imprisonment provisions for love jihad now has been introduced, mirroring many of the changes in UP, increasing penalties for unlawful religious conversion. The government also pronounced only Sattvic food will be served for the VIP, ending the VIP culture. The government also has taken the decision to bar the candidates from other states getting into the government jobs in Assam by securing the rights of the indigenous people and safeguarding their future. For example, in the manner how MP, Gujarat and Uttarakhand have followed their own domicile policy. Assam is also demanding for a classical language status to Assam. Kerala now has asked to declare the landslide as a national disaster, but let me tell you, a minister of the union government, Mullapalli Ramachandran, in 2013 in a query to the Lok Sabha has said that there is no such formal designation as national disaster, and the query was given with regard to the norms declaring a calamity as a national calamity, taking into consideration the severity. The reply further said that the government assesses the severe calamity on case-by-case basis, considering intensity and magnitude of the calamity, level of assistance required, the state government capacity to handle the situation, and flexibility available with a plan to provide relief. The leader of the opposition, Rahul Gandhi, had called for declaring the Wayanad landslide as a national disaster. Let me tell you, the National Disaster Management Act declares only natural disasters or man-made disasters, but not natural disasters of any kind. Natural disasters are cyclone, tsunami, heat wave, landslide, urban floods, flood and earthquakes, and man-made disasters are chemical, nuclear and biological. And we have global initiatives like the Sendai Framework, the Coalition for Disaster Resilient Infrastructure and Sustainable Development Goals dealing with disaster management. And the next most important issue is about the adage now coming up with regard to release of the Deputy Chief Minister of Delhi, Manish Sisodia, in the excise policy case, that jail and not bail is an exception, even in economic offences. The adage that bail and not jail is the rule came from the pen of Justice Krishna Iyer in 1977. Underlying the delay in the trial and the long period of pre-trial incarceration is the ground to bypass the stringent bail conditions in the money laundering cases. The Supreme Court granted bail to the former Deputy Chief Minister Manish Sisodia. In the case of delay coupled with incarceration for a long period of time, depending upon the nature of allegations, the right to bail will have to be read in Section 45 of PMLA, the court said. The court said that the PMLA Act prescribes the right of high bar for bail. The negative language in the provision itself provides that bail is not the rule but exception under PMLA. Both the trial and the constitutional courts are required to apply the triple test to grant the bail. This was what the Supreme Court. So what exactly is a triple test? It's three conditions. That is, number one, that there are reasonable grounds for believing that the accused is not guilty of such an offence, that he is not likely to commit an offence while on bail, and that the accused will not flight a risk. The bench held that the Constitution mandate to ensure speedy trial to the higher law compared to statutory provisions that fetter the grant of bail, and when trial is not proceeding for reasons not attributable to the accused, the court said unless there are good reasons, bail should be granted. So this is what was said by the Supreme Court, and now there is a no confidence motion moved against the Vice President of India, Jagdeep Dhankar, under Article 67 of the Constitution. The Vice President can be removed from his office by a resolution of the Council of States passed by a majority of the then members of the Council and agreed to by the Lok Sabha by simple majority, but no resolution for this purpose has to be moved unless at least 14 days notice has been given. And now at least 80 members of the Rajya Sabha have moved the resolution. Previously also there was a no confidence resolution moved against the Deputy Chairman of the Rajya Sabha. Harivansh, the parties had backed the resolution, including the Congress, the TMC, the DMK, the CPIM, the CPI, RJD, AAP, TRS, SP and Kerala Congress. But the chairman at that time, Venkaiah Naidu, rejected the notice, saying that it needed 14 days of notice and the resolution was not in proper format. So that was the first instance, and now this is the second instance. And the next one is about the Joint Parliamentary Committee of the Parliament being constituted to look into the Waqf Amendment Act, which was passed recently in the Lok Sabha, which seeks to rename the existing Waqf Act of 1995 along with the Unified Waqf Management, Empowerment, Efficiency and Development Act of 1995. It introduced in Lok Sabha, and it seeks to repeal the Musalman Waqf Act of 1923 and amend the Act of 1995. It regulates the Waqf property in India and defines a Waqf as an endowment of mobile or immobile property for the purposes of considered pious, religious, charitable under Muslim law. Every state is required to constitute a board to manage this property. The bill renames the Act to United Waqf Management, Empowerment, Efficiency, Development Act of 1995. Some of the provisions are: the bill calls for states that only a person practicing Islam for 5 years may declare a waqf, and it clarifies that a person must own the property being declared so. The government property, as the bill says that any government property identified as a waqf will cease to be so, and it deemed a government property that will update the revenue records. It gives the power to determine if a property is actually such a property. It calls for survey of such a land. It creates a central council, boards in every state. It also calls for composition of the tribunal. So, and it also includes provisions with regard to repeal of the orders of the tribunal and powers to the central government on this act. It also calls for a Waqf board for Bohra and Akha Gani. So it calls about the act allows establishing separate boards for them, but the bill allows separate Waqf board for only the Agha-Khani on the Bohra sects and not for the Sunni and the Shia sects. So these are some of the details of the act which was introduced, and now a joint parliamentary committee consisting of members of both the Rajya Sabha and the Lok Sabha has been constituted, and a privilege motion now has been moved against Dharmendra Pradhan. A privilege motion is moved by an MP when he feels that a minister or any other MP has committed a breach of the privilege of the House. 4 privilege motions have been moved: 2 against the Prime Minister Narendra Modi, 1 against Dharmendra Pradhan and 1 against the Agriculture Minister. So we have individual privileges and collective privileges for the members of the parliament and also the state legislature. For the members of the parliament, it's under Article 105, so that they can discharge their duty without fear and favor, and also uphold the dignity of the office as well. So these are some of the issues that I thought I should be discussing with you with regard to polity and governance for this week gone by. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my next post with regard to economy for the week gone by. That's from August 2nd to August 10th, and until then, it's very happy learning.